Thank you, Tom, for that interview, for that introduction, and thank you for your. This is what you expect from Duxbury in August, for the very warm reception here. I'm going to get the flogging out of the way first. There are copies up here of my most recent book, The Passengers of the Fortune 1621, of which there are, someone did count, there are 8 pages on Philip Delano. There are, of course, also references to the Aldens, namely Joseph's wife, who was a Simon or Simonson. And I will be happy to autograph and sign these books immediately after the talk. The other thing that I want to get out of the way is that this is principally going to be historical and legal. Those are my day jobs. And I am not going to be talking as a theologian, although I play one on TV. And so that's just the disclaimer in order to start out here. The topic is the prosecutions for fornication in the Plymouth colony from 1620 to, well, eventually to 1694, but 1692 is the concluding date for the Plymouth colony. And if we can go to the, let's see, I'm not going to move around to see this. So it's going to be divided into 3 parts, just like Gaul. The first, so if the next slide is on what was the status of fornication, or how was fornication dealt with in England at the period, so that you can see what is happening at the same time, the patterns that were there when they came to this side of the Atlantic. This next slide is talking about prosecutions for fornication, particularly in the New England colonies in this period of the 17th century. And then the next slide will be talking specifically about what happened in the Plymouth colony, and that's where we'll get all of the long stories. So the next slide, please. 17th century audiences were well accustomed to hearing sex outside of marriage condemned. The form prescribed for the solemnization of marriage reminded those present that marriage was ordained for a remedy against sin and to avoid fornication. The church courts had long been responsible for punishing those who engaged in illicit sex, and their role in so doing may have become even more significant in this period in the 17th century. Note, however, this is the church courts in England rather than the civil courts, because this was an ecclesiastical offense and not a civil offense. The next slide, please. And I think that should be a copy of the first page of the canons of 1604. And those canons confirmed that the church wardens of East Parish were required to submit regular reports on parochial matters and to identify those who had committed fornication, whether or not they had later gone on to marry. Those who had married irregularly, namely not in accordance with the form prescribed, and married couples who were no longer living together. If it was uncertain whether a particular couple were married, they might be cited before the ecclesiastical courts for living suspiciously together as husband and wife without being married. Those accused were then required to appear before the court and might either confess the offense or defend their actions by claiming, when accused of fornication, that they had in fact married before or at least shortly after having sex. It was a process, and this process had a number of aims. Not only the reformation of the offending parties, but also the prevention of further offenses by others who, in the language of the canons, seeing due execution done according to the nature of the offense, may fear to offend, lest a worse thing happen unto them. Now, this system of presentations was, of course, dependent on the knowledge of sexual transgressions coming to the attention of the church wardens. But the general lack of privacy and the widespread support for the prevailing moral standard would enable many relationships to be detected. The regularly made allegation that the relationship in question was a great scandal and offense to sober persons in the neighborhood was not just a form of words, nor was such scrutiny motivated simply by curiosity, much less prurience. Self-interest played an important part here. At a time when religious authorities taught that there was a link between morality and prosperity, there was a fear that the community as a whole might suffer from the transgressions of a few. As one of the historians of the early part of the 17th century in England writes, immoral acts were not regarded merely as matters for the private conscience, but as social and political ills that were subject to the sanction of public authority. At a much less elevated level, there was the very practical fear that illegitimate children who gained a legal settlement, residence, in the parish of their birth would be a drain on the parish's resources and thus a drain on the taxpayers' resources, because that is who would be responsible for supporting them. Now, of course, this is not to claim that all illicit sex was known to the community and reported to the church wardens. But it is clear that local communities did cooperate with their parish authorities, and that the system of supervision was not one that was simply imposed from above. A lot of it was from the ground up. Indeed, on occasion, the community might even be keener for the prosecution of offenders than the authorities were. Respectable parishioners often felt deeply resentful if officers failed to present a notorious offender, and the church wardens could themselves be presented for failing to present and report offenders. Further disincentives to tolerance were provided by the fact that it was not only the parties to the relationship who rendered themselves vulnerable to censure. Those who connived, in the words of the law, at the relationship might also be presented to court. A few examples to illustrate just how far this might reach. In 1606, James Gates was presented as an accessory to the incontinency between his daughter and the rather oddly and inappropriately named William Good, while in 1632, Robert Lincoln faced the accusation that he had countenanced his brother's relationship with the servant and had dissuaded him from marrying her. Similarly, Isabel Gath found herself accused in 1609 of entertaining a woman that was with child in her house, and there she is brought to the bed of her bastard. The system was designed not only to discourage rather illicit sex, but also to ensure that the offenders had no support from the community. The next slide, please. Those men and women adjudged to be guilty of sexual offenses would be required to do penance. This involved the public confession of one's sins while clad in a white sheet and holding either a candle or a white rod. The severity of the offense was marked by the number of persons before whom such confession had to be made. A minor offense could be expiated before a select group of church wardens, while the more serious offenders might be required to appear before the whole congregation. Similarly, if the parties had married after committing fornication, then they might be allowed to do penance in their normal clothes and without the white rods or candles. Those who remained unmarried would be enjoined to separate. And thus in 1735, one Richard Whitton denied his relationship with Mary Rudd, but was admonished to separate from the company of the said Mary Rudd, giving scandal to the parishioners by living together. It was, however, possible for penance to be commuted to a fine. In 1752, for example, John Dawson and Jane Briscoe were accused of cohabiting. Dawson appeared before the court to admit that he was guilty of fornication with Jane, his now wife, and asked for his penance to be commuted to a sum of money. And the court accordingly decreed that he should pay 40 shillings to the minister and church wardens of their parish for the care of the poor. Such payments may inspire a certain amount of cynicism about the motives of the church wardens in presenting couples. While commutation was in fact pastoral in its origin, in that there might be circumstances in which it would be undesirable for a person to do penance, it was only too easy for reformation of an offender to slip away and be replaced by the hope of financial gain. One Yorkshire incumbent fretted that his curate had allowed some private penances to be performed, which I fear will never affect a reformation of morals, for even the country people talk of them as mercantile wares to be bought, sometimes cheaper, sometimes dearer. And yet this did not necessarily undermine the efficacy of the system in acting as a deterrent for those without the money to pay such fines. Of course, there were some who ignored the summons to court and the subsequent sentence. In this case, the courts would pronounce the recalcitrant parties to be excommunicate. And in a society whose entire structure of thought was dominated by religion, this could be a very powerful weapon. The next slide, please. The details of the process bring home just how much effort the church courts put into the supervision and punishment of the offenders, but they were not alone in punishing illicit sex, nor was their jurisdiction uninterrupted. While the ecclesiastical courts had exclusive jurisdiction to the exclusion of the civil courts over punishments for fornication and adultery, the common law courts also played a role in the regulation of morality, although much depended on the local initiative. The first house of correction had opened its doors in the old Bridewell Palace in Blackfriars in the 1550s, or rather doused them on the inmates, with the aim of reforming the recalcitrant. And the grounds for commitment to such a house of correction included adultery and bigamy, as well as more obvious offenses against public order, such as prostitution. The initiative and the name of the original bridewell proved popular, and by 1630, a network of what were called bridewells covered the whole of England. Legislation also envisaged the punishment of parents of illegitimate children, while leaving the precise form of such punishment to the discretion of local justices of the peace. More drastic measures were introduced under the Commonwealth, following the abolition of the church courts in 1647 under Oliver Cromwell. In 1650, the next slide, please, an act for suppressing the detestable sins of incest, adultery, and fornication prescribed that sex with an unmarried woman carried the risk of 3 months imprisonment, while adulterous sex with a married woman could incur the death penalty. And these were by the civil courts, since there were no longer any ecclesiastical courts. However, the very harshness of the penalty may have made juries more reluctant to convict, and the death sentence was rarely imposed for adultery. Its effect was primarily symbolic, a public assertion of offenses to be abominated. Now, in the event, the 1650 Act was in force only for about a decade, and in 1660, the church courts were restored, as well as the previous ecclesiastical law. There were, however, a number of new restrictions on the powers of the church courts, and the 1689 Act of Toleration, which sanctioned non-Anglican forms of worship, raised new questions about their role. If there was no longer a universal system of religion, could there be a universal moral code? There has accordingly been much debate as to how effective the ecclesiastical courts were in this period after the Restoration in 1660, and at what point they effectively ceased trying to detect and punish moral offenses. So that's the state in England. The next slide, please. Talking about New England. Judges in New England also strove to help religious authorities eradicate sin. Since there were no ecclesiastical courts, we're now talking merely about, or only about, the civil courts. One sin that was prosecuted with greater or lesser frequency was fornication, a sin that, in the words of New Haven magistrates, shuts out of the kingdom of heaven without repentance. Single women were punished for getting pregnant, and many more young couples prosecuted for having a child less than 9 months after they were married. The next slide, please. I'll be talking not only about Plymouth, but about others of the New England colonies, starting with New Haven, a separate colony in the early part of this period. In New Haven, a defendant and his wife were whipped for their filthy dalliance together. 2 servants were prosecuted for diverse unclean, filthy dalliances, and a 3rd servant whipped for defiling himself by diverse unclean passages with one of his master's children. Similarly, in Plymouth, a young couple was whipped for unclean practices with each other, while on the other hand, when Jane Powell explained that she had committed fornication with an Irish servant out of hope to have married him and thereby escape her sad and miserable condition by hard service, the Plymouth court ordered her cleared for the present and simply sent her home to see if she was pregnant. Single men were also prosecuted for fornication. The next slide, please. And a man would be required to support a child he was accused of fathering if it shall appear to be his. But many prosecutions encountered difficulties. If a woman failed to prosecute a man, he would be cleared. An accused father also was entitled to a trial by jury if he demanded it. And the courts treated men accused of fornication fairly and were careful not to convict the innocent. The judiciary's sympathy for men emerged with special clarity in the rather weird case of John Ufot, who, after being divorced from his wife for insufficiency, managed to get Martha Nettleton pregnant. Although he was sorry for his sin, he was now convinced that he would not have suffered from impotence if his wife had carried it toward him as she ought. Finding the need of that help from Martha, he was, by the power of temptation and corruption in his own heart, overcome, and accordingly sought the court's permission to marry Martha. And although the court found it is a strange thing that after all this he should miscarry in this manner, it allowed John and Martha to marry, of course, after fining both of them. Judges were much less sympathetic to women, as for example, when Martha Richardson testified that a man unknown to her impregnated her after she had passed out in a fainting fit. And the court ruled that it could not but judge her guilty, both of known fornication and continued impudent lying, believing that no woman can be gotten with child without at least some knowledge, consent, and delight in the acting thereof. Another sexual sin that was prosecuted with some frequency was adultery. Death was the official penalty for adultery in several of the colonies, but in most cases, adulterers received lesser punishments. The only colony in which adulterers were executed was New Haven. For example, a married woman in Plymouth who committed uncleanness with an Indian was only whipped at a cart's tail and required to wear a badge, while there is no record of the outcome of two other Plymouth cases. The first, in which a man was accused of lascivious carriage in grabbing a married woman's clothes and enticing her by words, as also by taking out his instrument of nature, that he might prevail to lie with her in her own house. And the second, in which a woman was presented for the sin of fornication with her father-in-law. Next slide, please. When you're looking at the law in this particular era, starting in 1636, there is what was referred to as the general fundamentals. And before that, it was a combination of English common law and the first 5 books of the Bible, the Torah, the Mosaic law, which was enforced by the proclamations of the General Court. The colony of New Plymouth had land patents, but it quite famously had no charter. So Plymouth's lawmaking authority was not set forth by a royal charter, as it was with all of the other colonies. So no law was based on authority granted expressly. Plymouth was in this relatively unusual, if not unique. The population in 1636 is a bit fewer than 3,000 inhabitants. There were a series of, and I think it is 6, but it might have been 7, capital crimes. Adultery was one of them, but as you may know, only one person in the history of the Plymouth colony was executed for a crime other than murder. And that was Thomas Granger, the servant of a man of Duxbury, who was executed in 1642. for bestiality. The first execution for murder was John Billington in 1630. And all of the executions that took place in the history in the history of the Plymouth colony, with that one exception, were for murder. Between 1633, which is the first prosecution for fornication, and 1691, there are 82 cases of fornication that they were presented. Now, in this, I also include the titles of uncleanness, carnal copulation, and the births of illegitimate children, and I include that with the fornication. The enactment of 1645 outlined the punishments for the crimes of fornication, and that distinguished between acts committed before and acts committed after the time of the marriage covenant. The fine for fornication after contract was £5 per person. Half of the fine for fornication before contract. Interestingly, only 5 of the 82 cases clearly occurred during the period of the marriage contract. So after what we might call engagement and before the parties actually join in marriage. The next slide, please. There's a chart here from the Plymouth Colony Archive Project, and I'm assuming this is a pie chart. The chart shows the percentages of fornication cases that occurred in the Plymouth Colony during this period. And it is divided between the period of contract, before contract, but between couples who eventually married, and completely outside of intended wedlock. The split between those who eventually married and those who never married is almost a 50-50 split. Throughout the history of the colony, the punishment issued to those committing fornication was most commonly either a fine or a whipping. The next slide, please. In the event that the woman involved became pregnant with an illegitimate child, the man had to marry the woman or pay regular sums of money to the mother for the keeping of the child. Before that enactment of June 1645, the punishments for fornication seemed to be of a slightly different nature than after that date. Fines were rarely issued. Rather, those accused were sentenced to sit in the stocks or to be whipped. And what I think is adding insult to injury, Francis West was even told to make a pair of stocks within the next 2 months and then to sit in them. So he not only was published by being put in the stocks, he had to make the stocks himself. A curious characteristic of several convictions in the early 1640s was the unequal sentencing given to men and women. In each of the cases, the man suffered corporal punishment, while the woman either sat in the stocks or was forced to stand by and watch the man being beaten. After June of 1645, however, the distribution of punishments was more equal. However, some cases emerge where only the male appears to have been punished. In these cases, the woman's name is not mentioned, and the fine paid was half the amount that it should have been. Moreover, the short imprisonments suggested in the 1645 Act were either not carried out or did not get written in the records. The first case of fornication heard by the court after the approval of the act best illustrates the upholding of the law, except for the curiosity that was mentioned above. In those cases, the wife was not sentenced at all. On the 27th of October, 1646, John Thompson, coming into this court and acknowledging his fault of incontinency with his wife before marriage, but after contract, was fined £5 and imprisoned according to order, but paying his fees was released of his imprisonment. What happened to Mrs. Thompson? Under the law, she was also subject to a £5 fine. Now, for the most part, the fornication cases follow a pattern, but amongst them, some interesting ones stand out. I've already mentioned the servant, Jane Powell, who admitted to fornicating with another servant, yet escaped punishment by pleading she was allured thereunto by him going for water one evening, hoping to have married him, being she was in a sad and miserable condition by hard service, wanting clothes and living discontentedly. The court saw her expressing great sorrow for her evil and chose to clear the sentence and send her home. The next slide, please. While Jane Powell received no punishment at all, several individuals were issued sentences that seem a touch harsher than the rest. Sarah Ensign, for committing whoredom aggravated with divers circumstances, was sentenced by the court to be whipped at the cart's tail, a more severe whipping than at a post. In June of 1661, Thomas Berge Jr. found guilty of committing uncleanness with Lydia Gaunt. His sentence included a double whipping, but the records indicate a debate concerning the capital letters to be worn according to the law. Did Thomas commit adultery? Letters were generally not worn for non-capital offenses, and this case says that they were to be worn according to the law. The only law that spelled out the wearing of letters was that of adultery. 2 cases of incest were included among those of fornication. While there's no specific law outlining the punishment for incest, the record of Christopher Winter's hearing in March of 1668-69 declares it a very heinous and capital crime. Neither case brought a full guilty verdict, so I can't say how it would have been punished. But the first case between Thomas Atkins and his daughter, Mary, was presented before the Court of Assistants on the 7th of August, 1660, and was ruled in the General Court on October 2nd of that year. The jury found Atkins not guilty of incest, but did rule that he was guilty of offering some unclean incestuous attempts to his daughter while drunk. He was sentenced to corporal punishment by whipping. On the 2nd of March, 1668-69, Christopher Winter and his daughter, Martha Hewitt, were presented to the Court of Magistrates under suspicion of committing incest. 7 points of suspicion were presented, and Martha's husband, John, and his father, Thomas, each testified before the court. In June, the case came before the General Court, but the Grand Inquest found not the bill, and so he was released. The suspicions presented to the court included Martha's adamant refusal to name the father of the child she was begotten with, and Winter's indulgence to his said daughter since this wickedness, although known formally to be very austere to his children. The next slide, please. So talking specifically about cases in the Plymouth colony. The first prosecutions for fornication, as I mentioned, took place in 1633. The last in the Plymouth colony took place in 1683, so that we are talking about 50 years, more or less. And this was 10 years before the demise of the colony of New Plymouth. The first 2 were adjudicated on the 1st of April, 1633. John Hughes and Joan, his wife, adjudged to sit in the stocks because the said Joan conceived with child by him before they were publicly married, though in the time of contract. And John Thorpe and Alice, his wife, likewise adjudged to sit in the stocks, and immersed in 40 shillings fine because his wife conceived with child before marriage. But in regard of their present poverty, 12 months' time given for payment. So I guess they were put on credit. There do not appear to have been any prosecutions for any of the passengers of the Mayflower or the Fortune for fornication, although it depends on how you classify the case of Peregrine White, who was, well, a passenger on the Mayflower in utero, and was prosecuted for fornication on the 6th of March, 1649. There were, however, several prosecutions for fornication of both men and women in the subsequent generation. And I've tried to be as welcoming and inclusive as I could be of the Peter Brown descendants, but either, and this either is for better or for worse, I have not been able to find any records of any Peter Brown descendants being prosecuted for fornication. However, with Alden and Delano, there are, well, more than one. So Esther or Hester, they're variants of each other, Esther Delano, Delanoy, and Rebecca Alden were said to be with child in 1661. And this scandalous gossip from Abraham Pierce Jr. was retracted in court on the 1st of October. So reading from the court record, October the 1st, 1661, whereas I, Abraham Pierce Jr., have foolishly and unadvisedly reported to Ruth Sprague and Bethia Tubbs at the house of Francis Sprague that Rebecca Alden and Hester Delanoy were with child, and that thereupon we should have young troopers within 3/4 of a year. I do freely and from my heart own my fault herein, and am heartily sorry that I have so spoken. To their great reproach and wrong, and the defamation of their relations, which I earnestly desire may be passed by of them all. And I hope I shall forever hereafter take heed what I do speak, and report of any at any time. The following year, on the 3rd of March, 1662-63, Elizabeth Soule and Nathaniel Church were fined £5 for fornication. Elizabeth Soule thereafter sued Nathaniel Church for failure to marry her and won a partial judgment of £10 and costs in October 1663. Elizabeth had actually sued for £200 and was only given 10. The charge of fornication does not necessarily imply that the woman was pregnant. The fact that Nathaniel Church refused to marry Elizabeth Soule and was not required to, and was also not required to provide any child support or give any money to Elizabeth for any reason other than breach of contract, would indicate that there was perhaps a stillbirth or a miscarriage or an early infant death. There's no record of any birth of a child to Elizabeth Soule at or around this time, and her one surviving child was male. On the 2nd of July, 1667, Elizabeth Soule was again charged with fornication a second time and was sentenced to be whipped, but no male partner was named. On the next slide. Thomas Delano married, presumably in Duxbury, between January of 1667 and the 30th of October, 1667, and married Rebecca Alden, daughter of, as you all know, Mayflower passengers John and Priscilla. Rebecca was born before 1649 and died between the 12th of June, 1696, when she was called a motherly woman, and the 5th of October, 1722, which is the date of her husband's will, in which she was not named. Now, it appears that this couple got something of a head start on family life, because on the 30th of October, 1667, Thomas Delano appeared before the Plymouth court for having carnal copulation with his now wife before marriage, and was fined the sum of £10. Now, the date that is given in almost all sources for their son Benoni's birth is exactly the same date that his parents were sentenced for fornication by the Plymouth court. A number of modern researchers consider this coincidence to make the date unlikely for Benoni's birth and appear to rule that out. But the name Benoni, the Hebrew for son of my sorrow, may provide a clue. However, this name is usually applied to a child whose mother died in childbirth. See Genesis 35:18. But in this case, it may very well have referred to another sorrow than the death of the child's mother, and instead referred to the sorrow of the public shaming and humiliation of the child's parents. And while the use of this name doesn't necessarily indicate the events of the date of his birth, it's also not incompatible with that interpretation. On the 4th of March, 1673-74, Nathaniel Soule was charged with adultery with an unnamed Indian woman. And on the 1st of March, 1674-75, both of them were sentenced to be whipped. And Nathaniel was sentenced to pay 10 bushels of corn, so being fined in kind towards the keeping of the child. Now, other than the Plymouth Colony Court records of March 1673 and March 1674, there's no further mention of the child and no way of knowing whether or not the child lived to maturity. There are no known descendants of that particular union. The next slide, I think, which should have really, really tiny type. That is all 82 of the prosecutions that I've been able to find, which is not excluding that there are others. That's all 82 prosecutions. I have printed out here some more of it. That's just mostly the names that are there. I think a lot of times people have said, and I will conclude with this, a lot of times people have said, well, there was a lot of fornication. And that was, for example, yesterday at the cemetery. Oh, there was a lot of fornication. That was happening all the time, everywhere. 82 in the space of just about 50 years, with no recorded prosecutions either before or after that, does not suggest the whole lot that is there. This is also not the kind of thing, as I mentioned, that was really all that easy to hide, given the lack of privacy in this particular era. But there are all of the names, and then if you can just go back, go to the last slide, I will end here, and if there are questions, I'll do my best. Yeah.
What can you tell us about Mary Latham? When I read Governor Winthrop's diary, apparently she was Mayflower Pilgrim, William Latham's wife, and had a little dalliance up in Weymouth, and Governor, I think Winslow, put it in the hands of Governor Winthrop, and Winthrop apparently wrote a lot about, and I thought that I had read it.
Yeah, it's in his it's in Winthrop's diaries. And but that would have been done outside of the court system in, you know, so it was handled. I mean, one of the things that may have happened in some of these cases is that people were shuttled across the border and dealt with in some other way. And so that's, I mean, that's a possible explanation because there's no court record. At least I don't think there's a court.
The only place I saw it was in the diary.
Is it? Yes, it's in his journal. Yes, yeah.
I have a question.
Yeah.
Spoke of Elizabeth Soule, the two instances. Was it 97 was the last of the two being prosecuted for fornication? Elizabeth Soule.
Yeah, Elizabeth. Yeah.
And
67. Yeah.
67.
Yeah.
You didn't mention that she married Francis West later, and they had a child. I've seen speculation that the second fornication was in 67. It may have been Francis West.
Yes.
I'm wondering, you haven't mentioned it, so I'm wondering.
Well, yeah, it's the only way that you can really, I mean, that is a reasonable conclusion for Elizabeth Soule, but you do that by looking at their son's name is Isaac, and I think I'm of the opinion that that is their only child, and that it's also going to going to New Jersey and back and forth, but he came back in order to settle his father's estate, and he's the only heir mentioned, so that suggests that there is at least and then you look at his age, and it looks like his age would fit him to be born about 1667. And so, but there's no record to either the name of this child or that there was a child to be born. But then that would also suggest that there was a marriage. So she was whipped, but there was the way that you can't show anything from at least that court record is that there is no man who is mentioned. So it's not Nathaniel Church at that point, but that who that is unknown.
So it would be speculation to say that it's the man.
Well, it's a reasonable conclusion, yeah, but there's no statement to that. Yeah, Tom.
Can you repeat the questions? We've got to.
Okay.
Repeat the question.
Fine. Yes.
Martha Ballard was a midwife in Maine during the early republic. Her diary has been published since. In her diary, she makes a statement that when she was attending a childbirth and the father was unknown, that the mother, the birthing mother, would state the name of the father. And that this was very important because the midwife would testify in court and would be taken as some sort of solid evidence. So I know that you're talking about a different time period, but is there anything about identifying fathers and how that works?
The question is about a midwife's identification of the father, and usually through the statement of the woman giving birth. And I mean, in this particular period, particularly when you're talking about prosecutions, if you're talking about something which is happening in court, the testimony of the woman is asked under oath in court to name the father and or to name at least her partner. And because you could I mean, obviously, if the woman is pregnant, you can tell, or you can at least guess how she got into that condition, but that some of the descriptions in the court cases talk about either the reluctance of the woman to name the father of the child or her partner, or her flat out refusal to do so, but that typically you don't have, typically it is done as a formal legal process under oath rather than, I mean, sometimes you would, depending upon the circumstances, try and get other people to testify. But the normal way that this would happen would be by testimony under oath during the court process. Yes. Yeah.
Sorry. This was from much earlier, but you may have just answered this actually in what you just described, but during the section on persecutions outside of Plymouth, you stated that it was necessary for the woman involved to prosecute or accuse the man as part of the undertaking is necessary. Could you elaborate on that? And do you think there was a lot of room for silencing? But then you just reminded me about the testimony under oath. So that might be the answer to that part. But was there a lot of room for silencing of the woman if her role was necessary to point the finger directly?
Yeah, the question is, well, if I can rephrase it, did the woman need to initiate this? And the answer to that is no, because a lot of times it would simply be people recognizing that the person is now pregnant, and so that would be how the case would be initiated. But they recognize that you, well, can't get pregnant on your own, and that you have to have had a partner in that, and where it was possible. And in some cases, it's not, simply because of the circumstances, whether it is because the woman refused to name the partner, or in some cases, the men were charged and the women were not. So that there are some cases of women being charged and men not being charged, but there are other cases of men being charged and women not being charged. But so that in a sense, each case is different. And if the woman refused to name the partner, then, I mean, pressure could be brought on her, but it was not the same as, I mean, she wouldn't necessarily be held in contempt or something like that. But it depends on the individual cases. Ooh, lots of them. So yeah, next one over. Yeah.
What about rape? How was that dealt with?
Well, that was one of the things when, if you noticed the transcription, the published form of the laws, there were the series. So fornication was considered to be a crime, so it's not a civil action back and forth, and rape would be. I have not checked on prosecutions for rape. They were less frequent than prosecutions for fornication, but that was viewed as a separate kind of crime, particularly because of the violence involved, where in the case of fornication, there would not necessarily be that kind of violence involved. So I haven't actually looked as far as either numbers or procedures for that. Let's see, yeah, in the back, and then we'll go to.
I was wondering, I remember there were engagement practices. You didn't mention what if, like a bundling board where the couple was getting to know each other, or chaperones with single women that were being courted? Now, that would be, I mean, the other people must have been fornicating in a different way. I mean, if it was a board in the bed, that would make a difference, and they were courting each other and getting to know each other. Was that, those are practices that I sort of remember.
Sure. Yeah, so that the question is with regard to engagement practices, and because note that the kind of the time frame that you're talking about here, so that they talk about contract. So there is when the marriage contract was put together, and that was, I mean, what we would now kind of view as, let's say, a form of engagement or something like that.
Each other then.
And but that is before they've actually married.
Right.
And so
This was before that, when they were just,
Mhm.
if the man was interested in the daughter of somebody and went and asked if he could have her hand, then he would court her.
mhm,
Now, that's pre-contract.
yeah.
Okay, well, were there some set practices like having chaperones to, like, your old aunt would be there, or your brother or something?
Yeah, I'm not, yeah, I mean, that you'll need to get, well, that's not one of the things that are in the law.
Okay,
And
what
so-
about before? I mean, I'm sure that there were practices to prevent.
Yeah, I mean, there may have been common practices, but that's another talk for another time. Yeah, all right, so, yeah.
I was curious to know, like, what would happen to the children if they were born before a marriage actually happened? Would there be any penalties for like the children on the children themselves if they were born from a woman before marriage or not?
Yeah, the question is on children born out of wedlock. And I think two things with that. The first is that there was typically a court order for their support, and that would usually last until the age of about 7. In some cases, as for example with Nathaniel Soule, we find that in 2 consecutive years and then nothing after that, which suggests that the child has died after that, because there's no longer any statement with regard to his obligation to support the child. So typically there would be some sort of arrangement or some sort of support that is worked out for the support of the child, and that would last until the child was 7. Then the other side of the question is the legal status of, I'll see, if you ask any of my students, my most famous lecture in matrimonial jurisprudence is on the 7 types of bastards. And so I'm not going to go into that, but there were some legal restrictions, and that's the nicest way that I can phrase it. There were certain legal disabilities to the status of being born out of wedlock, and that was spelled out in the law, so that there were certain occupations, certain things where you had to be born of legitimate marriage, and this. I think partially this was also a class distinction, and so that someone who was in the occupations, like for example, well, the ministry, that you had to be born of legitimate parents, and so that some of this was legal. A lot of it was simply societal. But that was something which was put together, or that was something which was commonplace in that period and in all legal systems well, even into the 20th century. So. Okay, let's see, in the back, and then we'll, yes, sir.
There should seem to be somewhat of an authority on bastards. There was a book today called Bastard about Richard Moore. I was confused because from what I could determine, according to English law, if the purported parents are married, and you know the mother is his mother, she was married to her cousin, but the child is called a bastard because
the father declared, yeah, this is Richard Moore, because I think the father declared that he was not the father was, he declared that he was not the father. I think in that court case, is that correct?
yes,
Yeah.
is that one of your 7 specific kinds of bastards?
Well, I mean, the first one was doing this, of course, all in Latin because I'm teaching canon law, you know, so that there was the, you know, you started with the natural bastards, and that is the, and that's the top, and then you go into the sacrilegious bastards and the various other things depending upon the circumstances. But yeah, I think that the reason why, I mean, they were bundled off. And it wasn't just him. I think there were 3. Is that right? 4. Yeah. And they were bundled off. But that was, I believe that the court case was because the father declared that he was, or the husband. Let's say it this way: the husband declared that he was not the father of those children, and apparently they bore a striking resemblance to one of the farmhands.
Yeah, I think we should maybe do 2 more questions.
Okay.
Yep,
Sure.
it's time for a
Yeah.
wedding.
It was about the Moore children. How could the Pilgrims, like Brewster and some of the others, have taken those children away and taken them away from the mother? I've always been troubled by that story about the Moore bastard. One of them, they didn't all survive. Ellen didn't survive,
I think Richard is the only. Yeah, I think Richard is the only one who has.
and he has some
Descendants,
legacy,
yeah.
children. So, but I just don't understand that the religious people on the Mayflower thought that that was okay. I mean,
Well, on the other,
what is the?
on the other side, you know, they, you know, your choice is you know, you can give these to people who will give them a home, who will take care of them, who will give them a good religious upbringing, or you can throw them out on the street. And which choice do you have? Because the mother is not allowed to have anything to do with them. So, yeah. So, you know, I think that this was, a, you know, they had a better chance and certainly a better life than they would have had, particularly with the stigma of bastardy about them. And here's the possibility of a new chance. So,
All right.
well, yeah, one more. Okay. Yes.
Right, yeah.
Yeah, go ahead.
Thank you. Okay, the novel by Nathaniel Hawthorne, The Scarlet Letter, how true would that be? Would women have to wear a red letter A for adultery?
You mentioned letter.
Well, both women, yeah, so this is about Scarlet Letter. Both women and men would wear letters, and this was typically for capital crimes. So probably adultery was by far the most common, but a number of others, like for example, in cases of burglary, and that may have been less frequent. But typically for capital crimes in which the person was not in fact executed, there would be a there would be a letter, but that was adultery was not the only one, but it was one of the, and I think it was either 6 or 7 that are listed in the Plymouth statutes. All right, thank you so much. Yeah.